Hello friends. Welcome to Davy Learning. This is the first part of the drafting, pleading and conveyance. This course is mainly targeted for students who are preparing a law exam or pursuing in law. And this course is presented by me, Advocate Diveshwar Sharma. And I have completed my graduation in BA Honours. Postgraduate Diploma in Personal Management and Labour Welfare. Master in Business Administration, Specialization in Human Resources. Bachelor of Laws. And my hobbies are traveling and reading books. The topics which I have been discussing in this course will be drafting and the relevant substantive rules thereof in India. Pleading's function and essential of pleading. Plaint. Concept of memorandum. Sale deed. Promissory note. Drafting and the relevant substantive rules thereof in India. Drafting, it's the development and preparation of legal documents such as constitutions, statutes, contracts, wills, deeds, leases etc. Its important element are knowledge of law, knowledge of facts, to put those facts in a language. It involves thinking and composing, so as to give a correct presentation of legal status, rights and duties of the parties, terms and conditions, remedies etc. in a self-explanatory manner without any ambiguity. What principles govern drafting? The process of drafting is generally governed by 4 principles. 1. Formation of outline in a satisfactory manner. The draft is the skeleton of a document. This statement suggests that the prepared draft should be elaborate and should address all important issues. In a nutshell, a draft should be as detailed as possible, not be vague one, able to fulfill the consideration of relevancy, content unity, chronology 2, and coherence 3, such that every paragraph should contain one major point. 2. Emphasis on the arrangement of facts. A deep emphasis should be put on the manner in which the facts of the case are arranged. The facts should be arranged step by step to reflect an organized analysis of the problem. There must be uniformity and consistency in the presentment of ideas. Style and language. Style is an important factor for the transport of ideas. A clear presentation is an essential requirement for clear thinking. The style should be simple with the most appropriate use of legal terms that would convey the facts in a precise and simple manner. The language too should be simple and faultless. Illogical paragraphing, poor punctuation, incorrect spelling and other such language that virtually render a promising document to be worthless shall be avoided. Repetitions should be avoided. 4. Physical characteristics. The draft should be typed on standard quality paper, 20 by 30 cms, with margins of 4 cms. At the top and left side and 2.5 to 4 cms. On the right side and bottom. Other physical characteristics include numbering of each page, numbering of preliminaries in Roman numbers, I, 2, 3, and main text in Arabic, 1, 2, 3 etc. Number of pages should appear in the upper right corner 2.5 cms, from the top and side the body of the document to be double-spaced normally. Each paragraph should be intended 5 spaces and every paragraph should be numbered. All sheets to be strongly tied together. Rules of drafting. Following set of rules should be followed. Before making a draft, a design of it should first be conceived. One should make sure that none of the facts are omitted or admitted at random. Negative statements should generally be avoided. Technical language should be followed. The legal language employed should be precise and accurate. Draft should be readily intelligible. 5. Due care and attention should be placed on the rules of legal interpretation and the case law pertaining to the related matter. The drafted document should be clearly understood by a person who has competent knowledge of the subject matter. The draft should be self-explanatory as far as possible. The draft should be divided into paras and each para should contain a distinct subject matter. Arrangement of facts should be done logically. Use numbers and letters for subclauses and paragraphs. Choices of words should be such that they easily convey the meaning of the writer. The words used should reflect politeness in order to convey more in a kind, natural and justifiable manner. The draft should be read once or twice before passing it for consideration. Let's understand more about the quality of words required to be used. The draftsman should keep in mind that his words reflect the quality of the draft. And therefore, he must be very cautious about his choice of words. Following points should be kept in mind. Words should be used in the same sense. Active voice should always be preferred over passive voice until the passive voice makes the meaning clearer. Paragraphs, in modern usage, should not be started with the word that as was done traditionally. The draft should not all things at once. One thing at a time should always be preferred. Pleading's function and essential of pleading. Order I, Rule 1 of Civil Procedure Code, 1908, describes about pleadings, and it is stated that pleading shall mean plaint or written statement. Thus, pleadings may mean plaint and written statement both, or we can say pleadings combines both, plaint and written statement. In other words, pleadings are statements in writing drawn up and filed by each party to a case, stating what his contention will be on the trial and giving all such details as his opponent needs to know in order to prepare his case in answer. According to P.C. Moggia, pleadings are such statements which are written and prepared by each of parties in any suit. Its suit is framed, and the defendant submits his own written statement. The law of pleadings includes all those things upon which the in India by P.C. Moggia. The word pleadings has been defined in Judicature Act, 1873, Sec. 100. According to this, pleadings includes any writ or summon and any plaintiff's written statement about his claims and statements of defendant about his defense, and written statements of plaintiff in any counterclaim also comes under this. Thus, pleadings means plaint of the plaintiff and written statement of the defendant. Plaintiff demands relief through plaint. In England it is called statement of claims. In written statement, the defendant denies the demands made by the plaintiff in his plaint and submits his own defense in it. As a rule, in India, there are only two pleadings in a suit. 1. The statements of a plaintiff regarding his claim is called the plaint. In this plaint the plaintiff puts his case and cause of action with other necessary particulars as provided in the Civil Procedure Code. 2. On the other side, a defense is called written statement. In the written statement the defendant denies or admits every material fact alleged by the plaintiff in the plaint and also states new facts which tell in his favor, adding such legal objects as he wishes to take in his claim. These additional averments are called additional pleas. Objects of the pleadings. The main object of pleading is that both the parties must know their cases and allegations made by the other parties. The Supreme Court in the matter of M.S. Ganesh Trading Company vs. Moji Ram, A.1.R., 1978 SC 484, has stated two main objects of pleadings: a. the parties to know the facts of the cases, and b. to prevent deviations. Odgers says that the function of pleading is to ascertain with precision the matters on which the parties differ and the points on which they agree, and to arrive at certain clear issues on which both parties desire a judicial decision. The following are the main principles or rules of pleadings provided in the Civil Procedure Code, 1908. A. Every pleading must state only facts and not law. B. It must state all the material facts and material facts only. C. It must state the facts concisely, but with precision and certainty. D. It must state only the facts and not the evidence by which these facts are to be proved. 1. Pleading must state only facts and not law. The F and foremost important principle or rule of pleadings is that only facts of the case to be enumerated in the pleading but not the law. It is the duty of the court to find out the law. Parties of the case need not to state that which thing is according to law and which one is not in his pleading. The parties have to state only the facts on which their claim or defense relies. But there are some exceptions of this rule. In the following matters, law is to be stated in the pleadings: a. Judicial notice. b. legal objections, such as objections about res judicata limitation, estoppel, jurisdiction etc. c. Inference of law. 2. State only material facts and material facts only. The second fundamental rule of pleading is that every pleading must state material facts and only material facts. Meaning thereby that the facts other than the material facts should not be stated in the pleadings. Thus, this rule of pleading requires two things. 1. Pleading must contain all material facts. 2. It must contain only material facts and not otherwise. Which fact is material, and which one is not, it is decided on the basis of nature of every case. Every fact is material which is essential to the plaintiff's cause of action or to the defendant's defense. Facts which are not necessary to establish either a cause action or the defense to it are not material according to the provisions in Order v. Rule 2, for example, to give notice in the suit against the government under Section 80 of Civil Procedure Code. In the matrimonial matter, legal marriage is not performed between the husband and wife etc. are the incidents of material facts which are to be stated in the pleadings. 3. Facts not the evidence must be stated. This is the third fundamental rule of pleadings, that every pleading must state facts and not the evidence by which they are to be proved. Facts are of two types: a. Facts which the party is required to prove, that is facta probanda; b. Facts of evidence by means they are to be proved are termed as facta probantia. The material facts upon which the suit of the party depends are said to be the facts to be proved, and they must be stated in the pleadings. Converse to this, evidence by which facts are required to be proved must not be stated in the pleadings. In this regard, Order 6 Rule 2 of Civil Procedure Code provides that every pleading shall contain only a statement in the concise form of the material facts on which the party pleading relies or claim or defense, but not the evidence by which they are to be proved. For example, in the matters of specific performance of contract, the names of those persons need not be given under whom agreement of sale and purchase was performed, because this is the evidence-related fact. 4. Pleading must state the facts concisely but with precision and certainty. The fourth fundamental rule of pleadings that it must state the facts concisely but with precision and certainty. Although the pleadings are required to be in brief but with accuracy and certainty, pleading must be clear and definite and should not be sacrificed for the sake of brevity. But this does not mean that the facts, which required to be stated, are so much brief that it may lose its importance in the pleadings. The golden rule of pleadings is that the facts are to be stated in such a manner that essential thing must not be left and irrelevant things not to be included in the pleadings. Thus, there are 4 above stated fundamental rules of pleadings which are required to be observed by the parties while drafting pleadings. Note of plaint in detail. Introduction. Pleading refers to plaint and written statement. In plaint, plaintiff should allege facts about his cause of action. In fact, plaint consists of some contents, and it is mandatory that such contents should be present in plaint. What is plaint? Plaint is written statement of plaintiff's claim. Through plaint, plaintiff describes his cause of action and other necessary particulars to seek remedy from court for redress of his grievances. Followings are the necessary contents of plaint. I. Plaint should contain name of that court in which suit is brought. 2. Plaint should contain name, description and residence of plaintiff. 3. Plaint should contain name, description and residence of defendant. 4. When plaintiff or defendant is minor or person of unsound mind, plaint should contain a statement to that effect. v. Plaint should contain those facts which have constituted cause of action. In addition to this, it should also be described in plaint when cause of action has arisen. vi. Plaint should contain those facts which show the court's jurisdiction. 7. Plaint should contain that relief which plaintiff claims. 8. When plaintiff has allowed set off or has relinquished a portion of his claim, plaint should contain that amount which has been so allowed or so relinquished. 9. Plaint should contain statement of value of subject matter of suit not only for purpose of jurisdiction, but also for purpose of court fees. X. Plaint should contain plaintiff's verification on oath. Conclusion. To conclude, it can be stated that plaint plays important role throughout whole trial of any civil suit. It is admitted principle that no plaintiff can go beyond his plaint. Therefore, no plaintiff can demand what is not claimed in his plaint. Similarly, no plaintiff can produce any evidence, which is beyond his plaint. Facts. Mr. J. Shiva Reddy assault Miss Hansika near bus stand on 12th of May, 2012 at 9:00 am, motivated by ill will. Miss Hansika intends to file a complaint in court under Section 323 IPC. In the Court of the Judicial First Class Magistrate, Tirupati, CC number 13 of 2012. Miss Hansika, D.O. Radhakrishnan, Hindu, student, aged about 21 years, studying in 3-year batch, B.Tech, SV College, Tirupati, residing at SV Women Hostel, Tirupati, permanent residing of 43790, KS Road, Rajampet, Kadapa district within jurisdiction of East Police Station, Tirupati, complainant. Mr. J. Shiva Reddy, S.O. Nasima Reddy, Hindu, aged about 26 years, 4th year, B.Tech student, residing at Men's Hostel, SV College, permanent address 790, T Nagar, Rajampet, Kadapa district, within jurisdiction of East Police Station, Tirupati. Accused. Complaint filed on behalf of the complainant. U. Sec 200 CR. PC. 1. The complaint submits that she is studying 3-year B.Tech, in SV Engineering College, Tirupati. She knew the accused well. 2. The complaint submits that the accused had been behind her for last 6 months, but she never cared him. He wrote a love letter to her and she admonished him, then one day he pulled her up a surrey in the classroom and on her report he suspended college for a month. This happened on the 1st of May 2012. 3. The complainant submits that on the 12th of May 2012, she came to Tirupati bus station along her friends Yogi, Anitha, Valley to bid farewell to the hockey team of her college going to Visakhapatnam in Tirumala Express. She came out of the station and went to the bus station at about 8:00 p.m. along with her friends. She found the accused near auto stand. 4. The complaint submits that, while she was bargaining auto, the accused came there and abused her, that she was responsible for his suspension from the college, tried to grab her right hand. When she protested, he immediately stabbed on her left and right cheeks and also on her back with his fists. She cried loudly and the auto rickshaw drivers and passengers handed over him to police constable near the bus station. But he did not take the accused to police station, that it was a non-cognizable offense. Hence thus complaint was made directly. The complaint therefore prays that the Honourable Court may be pleased to take cognizance of the offence U per second 323 IPC and punish him according to law. Advocate for complainant. Concept of memorandum in detail. A memorandum of appeal is different from petition. Therefore, no enumeration of the facts of the case, no complaint against the high-handedness of the other party, no plea of the helpless condition of the appellant, and no plea for sympathy of the court should find any place in memorandum. The memorandum can be divided into 2 main parts. They are 1. Formal part. 2. The material part. In the formal part the following should be included. A. Heading of the case. This should begins with the name of the court. The name and address of the parties to the appeal should be given. The name of the appellant being given first. B. An introductory state of the appellant. This statement must give the particulars of the decree or order appealed from. C. The valuation of the appeal. Though there is nothing in the CPC to require that the valuation of an appeal should be written in the memorandum of an appeal, yet as and val or in court fees are after payable, it has become a common practice to enter the value of the appeal in the memorandum. 2. The material part of an appeal should include the following: a. Ground of appeal. I. The grounds of appeal or objection should be written distinctly and specifically. 2. They should be written concisely. 3. They must not be framed in a narrative or in an argumentative form. 2. The Honorable Chief Justice, and the other judges of the Honorable Court. The petitioner above named respectively shemeth. 1. The petitioner carries on the business of import of all kinds of machinery under the name and style of Gangu Imports, having his office at 42 Masjid Bandar Road, Hyderabad. 2. The second respondent is appointed Sec. 5 of the Import and Export Act 1956 and is authorized to process all applications for import under the provisions of the said Act. 3. On the 2nd of May 2011, the petitioners made an application to the second respondent in the prescribed form for import of certain textile machinery from Germany. The said application was accompanied by the prescribed fee of Rs. 2,00,000. Hereto annexed and marked Exhibit A is a copy of the petitioner's said applications dated 2nd of May, 2011. 4. As the petitioner did not receive any reply from the second respondent, the petitioner wrote a letter to expedite the issue of the import license in favors of the petitioner. In the said letter, the petitioners also requested for a personal hearing before any final decisions was taken in the matter by the second respondent. Annexed to and marked Exhibit B is a copy of the said letter of the petitioner date the 10th of October 2011. 5. The petitioner says that thereafter, the petitioner addressed 2 further reminders to the second respondent on the 15th of November 2011 and on the 4th of December 2011, once again requesting the second respondent to issue the necessary import license to the petitioners. The petitioner craves leave to refer to and reply upon the said reminders dated the 15th of November 2011 and the 4th of December 2011 when produced. 6. The petitioner submits that the application herein was made by the petitioner in Hyderabad. The second respondent has rejected the said application in Hyderabad and this honorable court, therefore, has jurisdiction to receive, try and determine this petition. The petitioner therefore prays, a. that this honorable court be pleased to issue a writ of mandamus or a writ in the nature of mandamus or any other appropriate writ, order or direction U/Art 226 of the Constitution of India, against the respondents ordering and directing them, I, to forthwith withdraw and cancel the said letter of rejection dated the 7th of January 2011 being Exhibit C hereto, 2. To forthwith disperse of the application of the petitioner dated the 2nd of May 2011 being Exhibit A hereto after giving to the petitioner as per the rules and guidelines relating to imports licensing. B. For the costs of this petition and C. For such further and other orders and the nature and circumstances of the case may require. Petition drawn by Mr. Kieran, Advocate, H.C., A.P. and settled by Mr. Ajay Babu, Senior Advocate Managing Director, High Court, APMS, India Trading Co. Note of Sale Deed in detail. Sale Deed. Sale deed is a legal document describing the transfer of right, title and ownership of property by a seller to a purchaser at a price either fully paid or to be paid in installments at a future date. The entire amount of sale transaction, also known as sale consideration, is paid at the time of registration of sale deed. Facts. Mahesh wants to purchase house from K. Nirmal at the rate of 1,50,000 draft a sale deed. This sale deed entered into between G. Mahesh, S.O. G. Ramesh Babu, hereinafter called the vendee, on this 13 days of September, 2010. Now this sale deed witnesses as follow: 1. This in consideration of an amount of Rs. 1,50,000 paid by the vendee to the vendor on the 13th of September 2010, the receipt whereof is hereby acknowledged, the vendor the owner of the property detailed in the schedule hereto, does hereby transfer to the vendee by way of seek of the property, or house, so charted in the schedule hereto. 2. The vendor hereby agrees with vendee. A. That the sold premises shall be held and enjoyed by the vendor absolutely as full owner of the property without any interference by anybody whatsoever. B. That the vendee shall be entitled to receive rents, profits and other incomes in respect of the sold premises without any interruption by anybody. C. That the vendor shall execute and perform every such act of assurance necessary for more assuring the said premises to the vendee. D. His heirs, legal representatives and assignees etc. at the expense of the person so requiring him to execute a paper. 3. That for the purpose of construction the expression vendor and ven shall include their legal representatives, successor and assignees etc. In witnesses, vendor. 1. Witnesses 1. 2. Witnesses 2nd, vendee. Schedule. Tirupati Town, Tirupati municipality situated at near Pasupathi Super Bazaar, housing bearing number 311414 and extent of 100 cents. East, House of Murali Mohan. South, Pasupathi Super Bazaar. West, House of Balaraj. North, House of Rajswari. Vendor. Q6 discuss the note of promissory note in detail. Definition, Promissory Note, Sec. 4. Promissory note is defined by Section 4 of the Negotiable Instruments Act. A promissory note is an instrument in writing containing an unconditional undertaking, signed by the maker, to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. An instrument to be a promissory note must possess the following elements. 1. It must be in writing. Mere verbal promise to pay will not do. The method of writing is important, but it must be in a media that cannot be altered easily. 2. It must contain an express promise or clear undertaking to pay. A promise to pay cannot be inferred. It must be express. A mere acknowledgement is not enough. The following are not promissory notes, as there is no promise to pay. A. Mr. A, I owe you Rs. 500. B. I am liable to pay you Rs. 1000. C. I have taken from you Rs. 150. Whenever you ask for it, I have to pay, but the following is a promise to pay. A. I promise to pay RAM or order R'(S.1, 500. B. RAM. I owe you Rs. 1,500 and promise to pay the same for value received. C. I promise to pay RAM 1,500 at Kanpur. Although the promise to pay may be opposed to public policy and unenforceable, once a promissory note is executed, the promise to pay is performed because a promissory note amounts in law to payment, and what vitiates a promise does not vitiate a payment. 3. The promise to pay must be unconditional. We have seen before that an instrument, to be negotiable, must contain an unconditional promise or order. So a promise to pay contained in a note must be unconditional. A conditional undertaking destroys the negotiable character of an otherwise negotiable instrument. But a promise to pay at a particular place or after a specified time or on the happening of an event which must happen is not conditional. For example, I promise to pay BR'(S.) 57 days after C's death is not conditional, for C is certain to die some time or the other. 4. The maker must sign the promissory note. The person who draws the instrument and signs it is known as the maker, and the person to whom the promise is made is called the payee. The instrument will be complete only when it is signed by the maker, even when it is written by him and his name appears in the body of instrument. Signature may be in any part of the instrument, and may be expressed by a thumb mark or any other mark, if the executant is illiterate. 5. The maker must be a certain person. The note itself must show clearly who is the person engaging himself to pay. Where the promises are more than one, they may bind themselves jointly or jointly and severally, but not in the alternative. 6. The payee must be certain. A promissory note must contain a promise to pay to some person or persons ascertained by name or designation or to their order. A promissory note made payable to the maker himself is nullity, but if such a note is endorsed by him, it becomes payable to bearer and is valid. 7. The sum payable must be certain and the amount must not be capable of contingent additions subtractions. Thus, if A promises to pay R'(S.500 and all other sums which shall become due to him, or to pay 180 and all fines according to rules, the instrument is not a promissory note. 8. Payment must be in legal money of the country. Thus an agreement to pay money or grain or to deliver 100 tons of iron is not a promissory note. 9. A banknote or a currency note is not a promissory note within the meaning of this section. They are expressly excluded from the definition, as they are treated as money and not merely securities for money. A promissory note or a draft cannot be made payable to bearer, no matter whether it is payable on demand or after a certain period. 10. Other matters of form like number, place, date etc. are usually found given in notes, but they are not essential in law. Specimens of a promissory note. R'(S.500.00 Delhi. November 4, 1998. On demand, or 6 months after date, I promise to pay RAM or order the sum of 500 rupees with interest at 6% per annum until payment. st/dash. Stamp. Gopal. Gopal is maker and RAM is the payee. R'(S.500.00 Delhi. November 4, 1998. On demand I promise to pay RAM the sum of 500 rupees only. st/dash.